When you got home, I don't know if Kaveh people are. When you got home, how long before you found out Joshlin is not there?
I got down, Putta was down, and taking our sitting outside, I was like, Putta, please get the test scan ready so we can find test. I asked Putta, where's Joshlin? He said, now, I asked not where's Joshlin, I asked where's the children. He said, Rico and Ray went to move out, and Joshlin is playing way around with a box, a loose box, and it was a loose box, playing way around.
How many hours was that, do you know?
I don't know how many hours that was.
Maar is dat iets wat in de gemeenschap wil zeggen voor ons te maken?
Dan zeg ik.
Wat heb je gezegd?
Ik kan nog zeggen, maar ook te blameren.
Hoe je ook te blameren?
Ja, ik wil voeten. En mijn maak, mij, hij had het iets als een mens gevoeld.
Ja.
Als een moeder. Hij maakt me zeer. En als je stress gezegd. Dat was ik zelf gaan doen. En ik het zelf nog blijven. Ik zeg het. Zo, al die dingen gaan voor mij. Dat kan ik niet eruit gaan. Maar ik heb nog eens gekregen te denken. Maar dat kan. En dat kan niet eruit op grond dat ik totaal aan kan doen. En die weet wat ik moet zeggen. En dan gaan alle. Ik zeg, die mensen wat niet zo belangrijk. En dan de oorzaak dan is dan. En ik vind het niet. Zal deze zaken niet wezen. Maar maak het van. Dat is een moeilijk van. Dat kan ik niet.
Dank je. Like as I said to you guys, I just had to bring the different versions because obviously I get called that Kelly is in trouble. Some community members wanted to kill them. And I said, I have to help. But I needed to answer some questions. I also have questions and it is natural to have questions. And my biggest question was a lie detector test. And she's willing to take it. They're going to take it tomorrow morning, 9 o'clock. We will know the result. And we'll tell what the result is. What. I just need them to speak because there's so much stories going around. We don't know who says what, but now we've heard from her. We've heard from the mother herself. Because people can say, Dayton said this, Michael said this, Eddie said this, but now you've heard that what has happened. We will know for, and the whole thing doesn't make sense to me, because now Renz said, I never sent the child. The other person was there, says, you did send the child. The child went to your house. She says, no. So these are information that, you know what you want to, yeah.
The police must know because they will talk to them.
I don't know, yeah.
The police must confirm all that information because the police talk to them personally. The police question them, the police open pocket, question Edna, Renz, and Nino.
So was er op de politiestatie?
Yes.
En dat is van de vrouw?
Yes.
Is het?
Yes.
Je weet niet wat de resultaten van de ondervraging zijn? Alright. So yeah, I wanted to first of all, because I heard that Kelly, that was shocked, how can she do this? And now she told me she didn't do it. People said, she told the people, stop searching for the child, stop searching for the child. I'm like, what? So your child is missing. You want people to search. And she told me, I've never said that. You heard for yourself. We will try to speak to Kyla and to whoever, just if they have another version. But as I said to you that die zaken is niet makkelijk. This thing is not easy. I can tell you that my heart goes out to this family and everybody should just to make up their own mind that we are not entitled to our own facts. the sisters on the live, ask her to join the live, I can. Kyla, if you want to join the live, I'm here. I can make you join. Somebody says views rents. We also heard about rents for the first time now. We will find rents. But the cops know about rents. Can you get to speak to the cops about rents? And if Kyla wants to join the live now before I go.
As we're running, maybe Captain Lombard, you close there. You can see where the shade is. You don't have to move the screen. We can just move the projector to now be on the shaded spot, so it will be to your left. There we go. And as the sun moves, we'll just have to keep on moving the projector.
Turn my laptop because now it becomes challenging to click on the screen.
Oh, I see.
Because the computer screen is now off center. But maybe if you turn it to my side, perhaps. See if I can see from here. Yeah, should be okay.
Are you okay now? Or you want to?
No.
You want to position the laptop towards yourself so that you can see.
Yes.
And as the sun moves, we will just have to adjust all the time. It's one of those things. I've indicated the other day, if we were, for example, in Cape Town, it would have been on the screens in the courtroom. But we have to MacGyver here, and it still works okay. And thank you, Fergus, again, for always be there. It's just an add-on, because people are going to complain about the sound. I know that. But it is what it is. As long as we can follow, and the sound is provided to us as an assistance, and it still works well. Yeah. Thank you.
Somebody says Kyla is here. So then we can get Kyla, then we can hear her version, because I must also tell you, Kay gave me a phone, and I saw our own conversation, and I listened to the one of voice messages, voice notes. So I'm going to give you another 30 seconds. Where's Kyla? Kyla, you can come in the live and people can hear you. If you want to say something.
Just for the record, the witness Michaela Daniels testified, and she referred to a live where she was invited in. It's fine. Now you can keep on playing. You can keep on playing. I just added on the video that's playing. We had a witness, Michaela Daniels, that testified. This reference is to Kayla, the sister of Smith, and she said that she joined a live with Gayton McKenzie.
That is correct, man.
That's just for context. Yes, thank you.
Mustang, just he's an excellent cop, right? He's an excellent cop. He's a what is Nicolas van Daniels? Daniels, right? It's Nicolas van Daniels. I'm just kidding. I'm just trying to, can I just try to connect again?
That is
So come on, guys. I'm excited for tomorrow because the line captain is there and she's willing to take it.
Colonel, just for completeness sake, can we skip to the one with Ms. Daniels? Yes, Michaela Daniels, because I see the next one is accused number 1. My Lord, with your leave?
Yeah, that's
just
fine.
for the sake of continuation.
Yeah, no, that's
Thank you.
fine.
Maar ik voel, dat is niet water. Maar hoe komt dat die spelen hakken is in die plakken staan met iemand die hakken te doen? Hoe komt zo'n die staan met een mens kan hakken?
Alright, that's what I am.
Op mijn communication moet je zeggen, ik ben bij gepraat met van, ik heb iemand wat samen in deze character gezet. Ik gepraat met de van in de main van confirm ik hier. Ik praat daarvoor. Ik ga zien met hem. Is paard moet je kijken als een maat goed is. We kunnen het niet daarvoor. We kunnen het niet daar in plaats staan.
Right, you may go to the next one then.
The last one, my lord, or must I go back to the...
There was one that you skipped when the prosecutor asked you to flip.
The last one, my lord?
Yep.
That's fine. Connect. I'm here with Joshlin's mom, but I'm going to say something and then she's going to have time to speak. Can you just help them? Alright, you saw Kelly said hi. We're going to talk about certain issues, but I want to get something off my chest before I let. This is not about me, it's about Kelly. But I just need to get something off my chest. Hello, I can't reach all. There's too many people coming on, so it's going too fast. We'll start in 1 minute. We're just giving more people a chance to get on. And then we're going to... I'm going to say something and Kelly's going to say something. And then everybody can make up their mind after that. Let me charge this here. So let me make sure I charge my phone properly. Right, if the sound correctly, it's 3 minutes past 1, we start at 5 past 1. We can't start later than that. We start at 5 past 1. So it's 3 minutes past 1, we start at 5 past 1. I really appreciate so many people when I help. There's some issues we need to clear. Because I don't want us to make a mistake of our lives. We might make a mess of mistakes which I want to talk about today. first time Kelly's really eating. It's still seeing fish or food. Seeing fish or food. I was starting 1 minute, it's now 4 minutes past 1. There's some issues we need to clear. Because this is very, very important. This is a matter of a child's life, the life of a mother, a family. And I want to thank all the people that are praying, because none of us know what happened. Thank you. Who are you? Where's the boy say? The boy coming. What is your name?
That's your name.
That's Kelly's other daughter, the sister of Joshlin, and this is the brother of Joshlin. What a beautiful boy with good manners. Such good manners. Hello? Hello? Sorry, mensen, hoe gaat het? Hoe gaat het met jou? Is het regent? Ja. Is er nog ijscream hoor? Rickon, are you want soccer or rugby or PlayStation? Hey, all right.
Just a moment, Kelly. Is there a reason why we should show these minor children? Because we know this is being publicized wide. If people want to do that on social media, I don't know why we should condone it in the courts. These are minor children that's now being broadcast all over their faces.
The concern was that if we had to cut out or edit the video in any way, then...
If there's nothing more of an interaction with Ms. Smith, I'm not going to allow it.
I think there is a little bit...
You've watched it?
Yes.
Can you fast forward past it,
Certainly,
please?
my lord.
I don't want to see the children on national television and on social media.
No, I confirm that, my lord. I agree.
Yeah.
And you know, we need to clear some issues here today. There's so many issues that goes around. Number one, they said that Kelly has sold a child. Her boyfriend has raped and killed the child. They say she's not crying. They say she's hiding something. Now, none of us know what happened. I don't know. You don't know. The best thing we can do is to pray and to leave judgment for the Lord. Imagine some of us that blame Raquel, blame Kelly. And tomorrow, she commits suicide. And we find out the truth. So what I'm asking the communities, let the cops, the detectives are doing a great work. But to have concerns is fine, that's why I'm having this life. But I also have concerns, which I discussed with her. And we're going to do that today. Then, for the Council of Appeal, please call the councillor. Councillor, I'm going to give you one instruction. Councillor, just so that you, I want to ask you This councillor, say hi to the people. Introduce yourself, councillor.
My name is Councillor Joshlin Smith.
What on, Mayor?
PR Councillor from QA and Saldanha Bay.
Have you been part of the search?
From day one, I've been part of the search. It's been hectic, but we are very positive.
You have helped every day.
Every day, every day, yes, every day.
You've been there for the mother.
I've been here for them.
So tell you the things, Kelly. Or,
Since day one.
so what is your instruction?
Okay.
You must go and speak to the other councils. There must be an urgent council meeting. This is an international case. There must be an urgent council meeting where the disaster fund, because we need buy food for the people sitting there. We need to make sure that people are eating. We need to make sure that the municipality makes money available to see how we can help this search and broaden the search for the South. So my instruction to you, Councillor, is
There's no further interaction with Ms. Smith. My Lord,
No more videos.
according to Colonel Morris's affidavit, there are two links that involve accused number 2. I don't see they've been copied as videos as yet, but I'm going to refer him to his statement and the link, and therefore you'll be able to access it through there.
Okay, so let's do that. Let's get past all the videos and then so we can switch off that screen and get the lights back on.
If my Lord will allow, then I can do that quickly.
If you want to utilize, is our router switched on? We also have a router that's on here. That's
Fine, my
switched.
Lord, I
Oh,
can
you're fine.
hotspot through the phone.
In 4.1, there's two links that you make reference to. It's interviews in a vehicle. Can you please play those for us?
Okay, my Lord,
Thank
I'll just
you.
set up quickly.
Thank you. Mrs. Cock, settle in. Did you get your medication? Thank you. It says, she said 4.1.
You can just bear with me, my Lord. I think I've excluded that purpose.
If I may assist you, Colonel, it's in your affidavit.
Yeah, I just need to
No problem.
So it's to open the affidavit and then
Yes.
do the hyperlink.
That's what I was suggesting, my Lord.
What time is your flight, Ms. Herman?
My Lord, I will be departing, I think, after this witness's evidence.
Well, if you could,
Saldanha's clinic, can you hear?
okay, sorted.
Can I operate from here, my Lord?
Yeah, but then you just have to get out of the projectors. Line of sight. The mic microphones where the interpreter normally uses it is live, so it will also pick it up. But you can operate it best you can. Yes.
Kali. Ons gaat van kry. That's right. Die mense soek nou vir hom. Almal soek vir hom.
My Lord, if I may ask Captain Lombard to just assist us with the projector. We
Yeah.
are literally moving as the sun moves.
Yes, thank you.
Proceed.
Huh? You know why? Wie zei? Het zei techno. Kom hier, Boeta. Kom hoor, ik wil je schiet mee, bro. Het gaat toch los. Kom. Kom hier, drie voorkant zo. Pak een politie toe. Kom, ons zet hem. Gaan die dan net hier komen, masterkant? Ja, kijk hier. Dat is voor ons af politie toe. Ja, hier is lang klaar mee, bro. Ik wil niet zo dat zoek jullie. Wat is het? Oh, als je naast me zo daar, Joshlin weg. Je komt er lekker mee op praten. En die is een groot zak, ze moet nooit voor zijn naam worden, nee. Dan moet je wat. Praat met de mensen. Saldanha Bay, ik kan niet meer gaan.
Is that it?
4.1, the second one.
Is there another one?
Yes, there is a continuation, my Lord.
I just need to get there, my lord. That's challenging.
Final video.
Oh, als je naast me zo daar, Joshlin weg. Je komt er lekker mee op praten. En die is een groot zak, ze moet nooit voor zijn naam worden, nee. Dan moet je wachten, dat er wat is. Wat is eruit? Kijk op wat. Hoe zie je wat er gebeurt? Kijk wat me gaan. Maak een filter, maak je wat er filter. Yes. Wat ik gehoord heb. Ja. Vind je gewoon nu? Goed als een paar van gaat verder. En het is om een oude bakken te roeren. Een korte verhaal, ja. Doe wat, Joshlin. Dus je was aan te roek. Dit is andere roek. Zo, Rensa roek ook. Dus die Rensa. Zo, Rensa doet dan hier wat gezond te roek. Maar waarom ze Rensa zijn niet geteken? Zij zijn niet geteken. Ze gaan nooit voor Joshlin gespeeld. Ze gaan worden gezien. Wat was dat? Sê, kom eens nie bij belang wat jy moet sê. Want jy kan voel die praat die waarheid. Sy sê, jylle geroek, en toe, ja? Toe roep sy met Joshlin. Sê, roep my kinderen was goed. So sê die laatste mens wat gesê, vir Joshlin gestuur het. Toe kom Joshlin nie meer terug. Sy was ook weg. En ek was so verstaan. As sy nou met Joshlin stuur, toe gaat sy saam. So Rensa het vir Joshlin gestuur. En besef sy met Joshlin. Toe kom hulle nie meer terug. Jy praat jy dan wat jy gesien het. Nee, hoe jy gesien het gehoor. Mens kan dit van sien en hoor. Hoe het jy was al? Ja. Yes. So. Hy het later wat jy met Joshlin gesien het. En sê nou wat Kelly Thailand wat gebeur. Ja. Kelly. Ja. Toen Joshlin nog weer uit het. Special. Redactor. Na Kelly die sakkie te gerook het. Dan sê my, daar gaan die vraag mee aan hoor. Daar wat julle koop man, hè? Dat hoef nie te sê my, weet jy, ja. Die gans, ja, ek weet al wat gans, so ek kan hom toe doen. Krijg je een skuld daar? Het jy al skuld gekry? En hoe kan ook? Skuld, dat weet ek nie, kan jy vat in die boek? Want dan jy geen mense skuld. Krijg dan is een skuld. Die stiefpa. Net voor de kansel en net voor die mensen zijn het ja, tot die weg. Hoe die mensen zeggen,
Any other videos?
That is all, my lord.
Are those all the videos?
Yes.
So we can effectively switch off that device and we can get the sound and stuff back.
Correct, my lord.
You're not going there again
No.
for now. Or let's just pause it, let's see.
I have nothing further for the witness, my
You've
lord.
got
That
nothing
is,
further.
that is the evidence.
Thank you. Mr. Harumse, any questions?
My lord, may I just turn my back on the court for a moment?
Certainly.
I have no questions, my lord.
Thank you. Mr. Kadai, any questions? Certainly.
Thank you, my lord. I have no questions for the
Thank
witness.
you. Ms. Kadai.
Thank you, my lord. I have no questions for the witness.
Thank you, Colonel. I have to apologize. was told that the defense wouldn't agree to receive the evidence in a different way. Meant you had to come all the way from Cape Town. We could have dealt with this in another way yesterday, without the inconvenience and without wasting the court's time and all the logistics that we had to put in place. But it is what it is. But thank you for availing yourself and a safe journey back. And I didn't use my magnifying glass.
Thank you, my lord.
Thank you.
That this statement of Colonel Morris be made available to your registrar so that those links can be copied, so that it can be uploaded for the record.
That will then be uploaded. Remember, there was no objection to the statement except for that.
Indeed.
The request was made it be played and the hyperlinks are in the statement. The rest of the videos, how is that prepared?
Those are on a memory stick that he has downloaded as video format. The last two that we played is the links there out of it.
So that will be, so the memory stick. No. A memory stick is a physical exhibit. So we have 3, if I remember correctly, or do we have 4? So check. You've got the 3 videos of, there were 2.
We have 4, my lord.
So we are now on exhibit 5.
Yes, correct.
So we're going to mark the memory stick as exhibit 5. And then we're going to link the statement to that. So this will be 5 and a small a in brackets. The reason for that is, if it goes with the documentary evidence, it might be lost in the sequence of the exhibits. And in this document, the links are there, which will then take you to real evidence.
The original to your registrar.
No, I need one. No, you don't need to give me the original, but I need one to be uploaded with the links. Because remember, this is a copy, so I can't link from here unless the statement is also on the video, on the stick. Is it on the stick as well?
I believe it is. And
I saw it on the screen.
It is. And what he's also done for the court, my lord, is the videos that Ms. Hanif had referred to, he's copied onto the same memory stick for us, and there were 2 videos of Ms. Lombard that is on the stick as well. So there's at least 3 files on it with the Colonel's statement.
As long as it's on that stick,
Yes.
you don't have to give me another copy of 5A.
Certainly, my lord.
Because once we open
The statement.
the stick, exhibit 5,
Yes.
I saw it on the screen,
Yes.
and we go to the file with a video,
Indeed.
with a statement, which is a Word document. I saw it when it was there.
Yes, my lord.
And then we scroll down, open it up, scroll down, click on the blue link, and it will take us to the videos.
In fact, all the videos are on that, can be accessed through the
So
link
that
as
will
well.
make it will make it easy, but it will also be easy for yourself and the defense to have a look at it if you want to.
Thank you, my lord. Thank you. We have the next witness ready.
Yes, thank
Sergeant Sangozi. My lord, if I may just turn my back.
Certainly. Are you going to lead the witness?
I think I'll make it. I don't think we should be too long with this witness.
That's a gentleman that used to sit there at the table where Captain Lombard is sitting, in that chair. Thank you. May swear in the witness.
Do you have any objection in taking the flag out? Do you swear that the evidence you're about to give is the truth, the whole truth, and nothing but the truth? Please raise your right hand and say, I do, so help me God.
I do, so help me God.
Thank you. The witness is sworn in. Mr. Sangozi, you may be seated. You know the drill. You've been here for most of the trial. I saw you sitting behind the laptop over there. You're going to testify in which language?
In Xhosa language.
Is it Xhosa?
Yes.
Thank you.
Thank you, my lord. Sergeant Sangozi is not on the witness list, so I have no reference number for him. He hasn't made a statement. May I have leave to proceed, my lord?
Certainly. Let's just get the interpreter comfortable. Thank you. You may proceed.
As it pleases the court. Sergeant, can you please tell the honorable court for how many years have you been in the service?
Sergeant bese ucela into yokubana uqale ixesha elingakanani usebenza apha esipoliseni iMzansi?
Iminyaka yami apha emsebenzini i-19.
19 years in the service, my lord.
Is it further correct that you fall under the command of Captain Lombard?
Ngaba kunjani into yokubana wena usebenza phantsi ko-Captain Lombard?
Inyaniso emsulwa leyo, my lord.
That's the honest truth, my lord.
How many years have you been with this unit? Oh, sorry, which unit is that?
Usebenza kuliphi icala bhuti kweyiphi unit?
Kwicandelo le-anti-kidnapping unit.
And-
Organized crime.
Anti-kidnapping unit and with organized crime.
And how many years have you been with the specialized unit?
Lixesha lingakanani usebenza ke kweli cala ke lo elikhethekileyo?
Unyaka wesithathu lo ndikuwo mna.
This is my 3rd year working within the unit.
Now, is it further correct that you were the person that actually noted the statement or the warning statement of one Humza Sikaka?
Ngaba kunjalo nguwe umuntu owabhala phansi i-statement ke sikaPhumla Segaqa?
Ewe ndim, my lord.
Yes, I did, my lord.
In what language did you communicate with Ms. Sikaka?
Ngexesha ke uthetha noMs Gaqa wathetha oluphi ulwimi?
Sasithetha amalwimi amabini, elesilungu nelesiXhosa.
We spoke 2 languages, my lord. We spoke in isiXhosa and in English.
The document itself is in English. When it was finalized, did you read it back to her?
Iqoqu elibenosebenzisa libhalwe ngesiNgesi, ngaba emva kokubana ke ugqibile ukwenza ubhala phansi ngaba wamfundela lona?
Ewe kunjalo, my lord.
Yes, that's correct.
What is the purpose of this?
My lord, I beg for a little leeway here. I will get to it.
No, I want to know.
My lord, the state had intention of calling Ms. Sigaka as a state witness, and up until the Saturday that passed, Ms. Sigaka has now disavowed herself from her statement. This witness was present, and that's the purpose of us
No,
having this
but
evidence.
so is that the issue?
Yes.
That he took a statement, and the purpose of the evidence is that the witness disavowed of that statement.
But it's not just the warning statement, my lord. There is another actual
I
witness.
just wanted to know, because if it becomes hearsay evidence and the purpose for which it is adduced, that might cause admissibility problems. So that's why I want to know. I don't want us to go down a road, because we've been there in this trial, and it becomes a dead end, and then my time is wasted. So I want to be clear. I don't want any inadmissible evidence on record. Yeah.
Thank you. And the second statement that you noted from Mr. Gaka was on the 13th of September 2024. Do you confirm that?
I-statement esesibini wasibhalayo sikaMs uPhumza Sigaqa besinge-13 kaSeptember 2024 ngaba kunjalo mnumzana?
Kunjalo, my lord.
Yes, that's correct, my lord.
If the only purpose of the evidence is that the witness gave statements and disavowed herself of the statements, what's the reason of presenting the evidence that she disavowed?
My lord, all we are anticipating is that if this witness is called, we're now making her available to the defense. If she is called, then we've already covered that in the state case. That's the only purpose.
But do I have to look at the statements?
No, I'm not producing it, my lord. I'm not introducing it as evidence. It's just to cover what was done as far as this person is concerned.
That's in the event the witness is called, so that
In
you
the
can
event.
declare the witness a hostile witness and cross-examine.
Indeed, it's for the purpose of cross-examination,
So
for
that's
the
the
state.
basis.
Yes, 100%.
Why didn't you tell me that when I was there?
I'm sorry, my lord.
Because there's another way of doing it, of course, but that's the long way. That's in the event that the witness is called, then you can apply to have that done, because then it's not your witness.
Yes.
In other words, you can cross-examine.
Indeed.
So why then laying this basis? Because if the witness is called by the defense, then it's not a state witness. Then you can cross-examine. So you don't need to lay this basis now, if that's the purpose.
I'm with the court, my lord.
You have to make a call whether you want to proceed with this evidence, because it will only, you can't cross-examine your own witness that you call. Then we go into the process of declaring that witness a hostile witness. In other words, now you have to prove and disprove and. But in the event that the defense calls the witness, it's not your witness. Then you cross-examine and you do what the defense have done. You drag out these statements and you say, oh, you made a statement here, you made a statement there, give us the context, You have the advantage, you consulted with a witness. Ms. Swanepoel told us yesterday. So it becomes a very risky exercise for the defense to call the witness. But if they don't call the witness, why do we have to go through this exercise?
We will leave it just where it is. I will not lead any further evidence of Sergeant Songozi. Thank you.
Akukho obunye ubungqina endizawubuza okanye into endizayibuza kwingqina eli.
So, Mr. Adams, any questions on the supported attempt? All he testified is his background and the fact that he took statements.
I have no questions.
Thank you. Ms. Nkabane? Thank you. No questions. Mr. Sivnarayan? Thank you. No questions. Thank you, Mr. Sankosi. You can go back to your seat over there or do what you have to do.
Ungabuyela kule ndawo uhleli kuyo okanye ke uyokwenza into uzoyenza mnumzana. Thank you, my lord.
Case, may I please ask that all the evidence that was led in the trial within a trial be encapsulated into the main trial and then the state closes its case.
Mr. Hanser, just on the request of the state that the evidence led in the trial within a trial be encapsulated into the record of the main trial.
My lord, I know, or I'm of the view that the statements that was found by this court admissible, that goes into the main trial, but not the evidence led in the trial within a trial as procedure, my lord.
No, but that was only insofar as it relates to the admissibility. But the evidence of the accused is what it is. And that's not for the state at this stage. So the statements that were admitted, that must be formally now to form part of the main trial, but I thought I made that order already on Thursday. Anything from your side, Ms. Nkabai, over and above what I've dealt with Mr. Haramse? Thank you. So the statement is already forms part of the main trial. Thank you, Ms. Herreman.
All I wanted was that the evidence, all the evidence of the state witnesses be encapsulated as well. It's not just the statements, it's the evidence led as well.
Like what?
From all the witnesses, that of Brigadier Hanana,
That's
Sergeant
evidence,
Forte.
that's evidence in the bigger scheme of things.
Yes, yes, that's all I want
Because
clarity.
I know that if the accused comes to the witness stand, you want to cross-examine on that,
100%,
which
my
you
lord.
would be entitled to do.
Thank you, my lord. That then is the state case.
Thank you. All right, any applications, Mr. Haramse?
The defense accused will not bring no application.
What application?
No application.
No applications, thank you. I'm now referring to the Section 174 applications, if there's any of that, so that I can deal with it. Ms. Nkabai?
No application, my lord.
Thank you. Mr. Sivnarayan? And now you can just... Are you going to bring an application in terms of Section 174?
That's good.
Yeah.
My lord, I didn't hear clearly. The defense officer number 2 would like to bring 174.
A 174 application. Thank you. You can bring your application. Ms. Herreman, if you want to be excused, you may pack up whilst we're busy. And then Ms. Swanepoel will take over. If I don't have the opportunity to wish you a safe journey and all of the best in your deliberations. Ms. Herreman is being excused to attend to a long-standing arrangement with the NPA. It's a training. Is it training?
No, I'm actually presenting.
You facilitating. Thank you.
Thank you, I'm indebted to the court. Thank you.
Yes, thank you, Mr. Kabai. I am all ears.
Thank you, my lord.
Section 174 on behalf of accused.
I am Ms. Mgabayi from Mgabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judicial instructions. Section 174 of the Criminal Procedure Act allows a court to discharge an accused person.
Ms. Mkabai, you don't have to take me to what Section 174 says. You can go straight to your application on the basis that it is brought.
Thank you, my lord.
I think I'm well aware of what Section 174 says. You will have noted when you came here this morning that my volume 2 was not on the bench. My volume 2 of the twin. And my registrar brought it in. I actually went to do the research on Section 174 last night and this morning.
Okay.
And I had a look at all the cases.
Thank you, my lord. Thank you, my lord. The defense will argue that accused number 2 has no case to answer on the following reasons. All the state witnesses that have testified in this case didn't bring any evidence that this court can come to a conclusion that accused number 2 has committed an offense.
All right. Now, what about the evidence of Ms. Lombard?
The evidence of Ms. Lombard, my lord, it was not credible.
What is the test to be applied by a court if the defense bring an application relying on the lack of credibility of the state's evidence? What is the test that I should apply?
Whether that evidence is reliable?
What are the authorities that you rely on? Remember, and I'm going to assist you. in some instances, the credibility of the state's evidence can be a factor to be taken into account at the stage of a 174 application. Now, there's a number of cases. One can think of Shuping, which is one of them. A well-known case in this division will be the Diwani matter, and the comments made by Traverso DJP in that case. But we must go back to where it was articulated of how the test is to be applied. Now, what is the authority for the proposition that you raised? Remember, I told you on Thursday, counsel that appear before me knows I'm going to ask you. So what is the authority for the proposition?
It's based on the following cases. First case, as the court has already quoted it, State versus Shopping, State versus Mayatebula, State versus Lubata. There are two legs that are...
Which of those cases are authorities in this division?
My lord?
Which of those cases that you refer to are cases in this division?
State versus Diwani is the case for this
Is
division.
it reported? Is State versus Diwani reported?
Even if it's not reported, my lord, but the principle is the same.
Whether it is reported.
When
That's all I want to know.
not yet reported, my lord,
Sure.
when I was
So if it's not reported, do you have a copy of the judgment? Did you look at the judgment?
I did, my lord,
Mm-hmm.
and it states as follows. State versus Diwani, 2014, in brackets, ZAW CHHC at 188, at paragraph 15. The legal position regarding the applications in terms of section 174 was summarized as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there's no possibility of a conviction, other than if he enters the witness box and incriminate himself. This
Well, that proposition is, of course, based on the Supreme Court of Appeal decision in Lubata, 2001. Did you have a look at that case?
Yes, I do have it, my lord.
What were the facts of the case?
Lubata, the judge in that case was Judge Nugget.
Judge Nugent was
Nugent.
an AJA and Nafsa was an AJA in 2001. Yes. What were the facts of the case of Lubata? Did you read the judgment?
I read the judgment, my lord.
Did you note who was the judge Akwo in Lubata?
I've noticed it was Nugent.
No. The trial judge. Do you know who the trial judge was?
No, I didn't notice the trial
Trial
judgment.
started on the 17th of September 1999 in a place called Springbok.
I focus myself.
No. You see, when one reads a judgment, I told you the other day, I'm going to ask you about the facts, but I can tell you about the facts. Because the trial started on the 17th of September 1999 in a place called Springbok. And do you know who the trial judge was?
No, I don't know, my lord.
Indeed, it was me. I was the trial judge in Lubata, Akwo, and I sat in Springbok from the 17th of September 1999. But the facts of Lubaka is important if you base your argument on that. And the difference between that case and this case,
Yes, my lord.
is stark. Because it was the statements made by the co-accused. In this case, your client made a statement. And also wasn't discharged on all the charges. Only relate to some of the charges. So I'm asking you, is that an authority for the proposition of the credibility issue?
I will argue, my lord, that the proposition in Shuping,
What year was Shuping?
my lord,
What year was Shuping?
I'll tell the court just now. Shuping was 1983, volume 2 SA, 109.
And where was it decided? Where was Shuping decided? Which court?
It's written BSC.
What does that mean? Which court was it deciding? Remember, we work on precedent. So I'm asking you, where was Shuping decided? Which court? I am bound to decisions of higher courts, which would include the Supreme Court of Appeal and the Constitutional Court and the full court of this division. And then you have judgments of single judges. I don't have to explain the law to you, but I'm asking you, where was Shuping decided? What does BSC stand for? Could you give me the full citation?
It's Shuping, 1983, volume 2 SA, page 109, in brackets BSC. In this matter, my lord, it was stated as follows.
No. I'm asking you which court. What does BSC stand for?
It's the Supreme Court, my lord.
Which Supreme Court?
Botswana.
Am I wrong? That was a judgment of Imstra J.
Yes, my lord. Himstra J rendered a judgment intended to provide guidance.
No, but I'm asking you which court. Because am I bound by a decision of another jurisdiction?
Yes, my
Correct. But you see, Shuping was reported in 83-2,
Yes, my lord.
volume 2. But there was a decision of this court, which was then the CPD reported, in volume 4 of 1983. To be precise, 1983, volume 4, page 262. And the ratio is to be found on page 263 at paragraph G, because in those days judgments didn't have paragraph numbers, so it was on the side. Do you know which case it is?
No, I don't know, my lord.
It's State versus Peta. Judgment was given by Williamson J.
I focus myself on the relevant matters for
No,
my
no, no.
application. Okay.
That is specifically relevant. Because the dictum I'm taking you to deals with a test to be applied. And if you had read the judgment in Lubaka, you will see it is also referred to there. Do you know what Williamson J. said in Peter? It's also quoted in the Tue, but he starts on close to the bottom of the page in the law report. And it's not a law report that's on Safri, because it's a 1983 decision. And the facts there was also a tour of force, so to speak. As was in Duwani, that's Lorraine Shalomba. But I'm asking what was the test?
The test, my lord, is as follows. I'll start with the matter of Shuping.
I don't take me to Botswana. Come back home. Come back home. And let's go to Court 1 in Cape Town. Because that's where the court sat in Peter. That courtroom in Court 1.
The test is one. The principle is one. In all the cases I've quoted, including the case that the court has just mentioned. First test is there sufficient evidence upon which a reasonable person can reasonably convict?
Right.
Number one.
So let's fast forward so that we don't waste time. Right. Let's accept the test that you can't tell me has been complied with as to credibility. Your client made a statement that I've admitted where he says he was with when Joshlin was delivered to somebody else. He went there to go and ask for his cut, his money. You saying on the evidence, even on his own that's been admitted, there is no evidence, because that's what the section says. There's no evidence on which a court may convict. And don't tell me about prima facie, because I don't know what that means in this context. See the textbooks right about that.
I'll say that, my lord, boldly. The statement that has been admitted by the court, we heard yesterday that version has not been corroborated. That version has not been supported. That version has not been confirmed. So the chain, my lord, has broken there.
So what?
So there is no evidence before this court.
Yes, is there anything else, Ms. Nkala, on the 174?
On 174, the second leg, my lord, on 174 is, it will be unfair if the accused person is brought into the witness box solely to supplement the state case.
Well, the test is, as I've just told you, is there a need for him to come and supplement the state's case? Because the test is no evidence upon which a reasonable court may convict, not must convict, nor will convict, but may convict.
I strongly argue and submit, my lord, that there's no evidence.
Thank you. Is that all?
That is all, my lord.
Thank you, ma'am.
Thank you.
Mr. Sivnarayan, are you ready? Your more substantial because the circumstances of your client's different.
That is correct, my lord.
Now, it's 10 o'clock. Are you ready?
My lord, I think it is an opportunity. If we could just have a short break. So
No, because I know that you're going to Lubaka,
Yes, my lord.
right? Because I was sitting with a very similar situation in Lubaka, very similar, insofar where co-accused had made statements, and there were the multiple charges, the 2 murders, the theft of the vehicle, etc. You will realize that the Supreme Court of Appeal confirmed my conviction on some of the charges. But on some of the charges, they said I should have granted a discharge. I was young then. It was almost 26 years ago. But I know and I anticipated that you would bring the application. Didn't expect an application for case number 2, but yours I expected. Also, I want to get my device in the event that you want to have a debate with me about some of the authorities. You can feel free. I'm ready for you.
Yes, in fact, my lord, the authorities I was intending referring to have been dealt with by the court this morning.
Good.
Yes.
So I don't have to get my laptop.
No, my lord.
So let us take a 10-minute break. Mr. Harms, have you decided what you're going to do?
Is this whether there will be an application in terms of Section 174?
No, I'm talking about evidence.
Whether
Because I'm going to deal with his application.
Yes.
When I come back,
Yes.
I'm going to give a ruling on the 2 applications, and
Yes.
then it's your turn to bat.
Yes, my lord.
Are you ready?
I would be ready. Yes.
You would be ready.
Yes.
Okay.
Thank you.
So take instructions so that we can start with the defense case of accused number 1 immediately after I'm done with Mr. Signarayan's application. I might not take an adjournment when the application is done because I have prepared. I've prepared myself for the applications. I've done my research, and I just want to hear argument, and then I'm going to shoot. And then we'll start with the defense case for case number 1. So let's take the adjournment now so that we can realign. Swanepoel can move back to that spot. We can take any devices that we're not going to need standing around. We can move those out of the way. We can get the lights on and so forth. It's 10:04. We're doing well with time. We might finish this case by Tuesday. The evidence. And if we're going to finish the evidence, I'm going to give you a day for argument. And I'm going to give myself a day for judgment. So you must start working on your arguments for the end of the case as well. 10:04, 20 past, 15 minutes. Everybody can realign. Get yourself ready. It's going to be a long day. Court adjourned.
My Lord, the state had relied on various and numerous witnesses in an attempt to prove its case. However, with regard to the offense of human trafficking, there was only one witness, Laurentia Lombard, who could testify in that regard. My Lord, with regard to her evidence, I submit that it was of such a poor quality that it should be rejected in its entirety by this court.
And you relying on Mpeta and on the unreported decision of Diwani.
That is correct.
Read with the other authorities, but also incorporating the test in Lubaka, more specifically, the impact of Section 35, the now Section 35, on the application when one applies 174.
Yes, my Lord, that there is a discretion by the trial court in that determination, my Lord. My Lord, another authority that I want to make reference to with regard to credibility is that of the state versus Ngwenya and others. My Lord, in brackets CC 157/2018. My Lord, this is a matter where Masopa J had presided. My Lord, this matter also dealt with the application in terms of Section 174, but also dealt with credibility. My Lord, it was stated in this matter that in certain instances where the quality of the evidence is of such a nature or so poor, the aspect of credibility, even if only to a limited extent, can be taken into consideration at this stage or when this application is being brought, my Lord. My Lord, as mentioned in dealing with State versus Diwani, it was mentioned that an accused person is entitled to be discharged at the close of the case for the prosecution if there's no reasonable or if there's no possibility of a conviction other than if he enters the witness box and incriminates himself. Further, my Lord, in deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may take into account the credibility of the state witness, even if only to a limited extent.
So the similarities is, of course, that there we also dealt with the 204 witness. I think it was Bongo, if I remember correctly. And then the cautionary rules, etc. What I'm considering is what weight at this stage, where the court has a discretion, the application of the cautionary rules would play in coming to the determination that no court can convict on that evidence. Remember, starting at Mpeta, it's basically that no court will believe this witness. Yes, and then the test will still be, when it comes to the credibility and the reliability, that the cautionary rule will be applied, where you deal with a co-perpetrator or co-conspirator, as in the case of Ms. Lombard's evidence. It will ultimately be taken into account, but what is the weight attached to all of that now? Because, and I'm thinking aloud in trying to crystallize the issue, when at the end of the state's case, at the end of the whole case, one will then, and I'm just referring to Laurentia Lombard now, the 204 witness, because she's the one implicating your client on her version, for what it's worth now. That evidence will have to be determined holistically, but that evidence of Ms. Lombard can be strengthened by other evidence, not from your client, so that's where the 35 self-incrimination comes, but maybe by the evidence of Mr. Apollos, Mr. Van Rijn, whatever witnesses they might call. And then you fall into the test of Lubaka, where is it appropriate not to grant the discharge where there's a possibility that the co-defendant's evidence might strengthen. It's a bit complicated without giving the reasons for a finding now, because the reasons for the finding is only given at the end of the case in the event that I don't grant the discharge.
My Lord, Section 219 of the Criminal Procedure Act is applicable in any event that these exhibits that were admitted by the court after the conclusion of the trial, within the trial, cannot be used against the accused in any event. My Lord, with regard to the weight of the evidence of the 204 witness, Laurentia Lombard, as correctly pointed out by the court short while ago, she is also a single witness in this matter, my Lord. Although other witnesses were called, with regard to the offense itself, she is the only one who could tell us what had happened. And being her single witness, her evidence had to be satisfactory with regard to every material aspect. And it is my submission that she had failed, or her evidence had fallen short of that, my Lord. And for that reason, and the fact that she was not credible, or she should be found to be not credible, I'm of the view that in that case, it would not be that there is very little, but that then there would be no evidence because of the inconsistencies, unsatisfactory evidence. Her evidence should be rejected, and that there should be no evidence thereafter, my Lord. Yes. My Lord, the evidence of the witness was riddled with inconsistencies. Throughout her cross-examination, it came out that she contradicted herself a lot. On her own evidence, she testified that her confession, which she had made, it was full of incorrect information or mistakes because she was under the influence. And on her own, she told this court that the Sunday before Joshlin went missing, she smoked drugs. That Monday, she also consumed drugs. So for that reason alone, again, her evidence is unreliable, my Lord. I say her evidence was so poor, and I want to remind the court that at some stage during a cross-examination, the court even posed a question to her and inquired from her whether she had taken drugs that morning because of the answers she was providing to the court.
The fact that if I find that she was unreliable in certain respects, does that mean she was unreliable in all respects?
My Lord, I would say so because it would be hard to determine.
Let me give you an example. Now, the evidence given by Mr. Apollos in the statement in itself cannot be used against Ms. Smith, even at this stage. That's tried. Also, at the final evaluation, unless he repeats it, it cannot be used against Ms. Smith. If he disavows the statement, that's one thing. If he doesn't come and testify, same thing, because he wouldn't have repeated it under oath. But let's just take one and just a piece of the evidence. I'm not going to deal with everything. The prosecutor must still address me. She speaks of a discussion that she overheard on the Sunday. Now, whether it was the Saturday or the Sunday, on that statement that was handed in of the chicken detective. But she tells us about a conversation she overheard between Ms. Smith and Mr. Apollos on the Sunday. That lays the basis for what happens on the Monday. Now, Mr. Apollos' statement, you will recall the portion that he testified to and confirmed to be the truth on day one of his testimony, relates to a similar discussion on the Sunday. Now, in the event that I find that portion of Mr. Apollos' statement corroborates Ms. Lombard, in that regard, then it can be evidence. I'm not saying it is, because remember the test here is may. You use the term prima facie. I don't see it in the text. I've seen it in some judgments, the term being used. I try to stay away from it, because as I understand the authorities, I mustn't look at prima facie evidence. So it could be that you have a single witness insofar as it relates to going to the car, and you have a witness that contradicts herself in that regard. But you might find, in cases where you apply the cautionary rule, going back to, you took me to 219, going back to section 208 of the Criminal Procedure Act, in my final evaluation, that I might find, because of the corroboration on one aspect or another, that that's a golden thread where I can rely on that evidence. Now, if that is so, we will sit with the evidence of Mr. Kutsia, of what he was told in August of the previous year. We will sit with the then corroborated evidence of the unreliable witness on your argument of Ms. Lombard, but confirming a discussion of what should happen to Joshlin on the next day. Then we know that there are some circumstantial evidence on what would have happened around lunchtime on that day. And I'm discarding for this exercise with you the content then of what Mr. Apollos and Mr. Van Rijn says the instruction is, and the red t-shirt and so forth. The next day, it happens as discussed on the Sunday, where she's corroborated, and then we have certain conduct by Ms. Smith from which certain inferences can be drawn. Will that be sufficient for, in the final analysis, upon which a court may make a finding of guilt on either the main charge, alternative charge, or charge 2. Because on the main charge of human trafficking, there are many elements to, and there are many possibilities that where it can be read in, as well as with the kidnapping charge. And I'm thinking aloud, if one follows that logic, and if it makes sense, will that not be a reason not to grant a discharge?
It would not affect my application in any way, my Lord, if it was only that one aspect. My Lord, there's still all the other elements of the offence which had to be proved and satisfied, and I submit that that has not been done as well. My Lord, in terms of the elements of the offence with regard to the exchange, all of those things, there were material contradictions in that regard, my Lord. And I submit that the evidence was or of a very bad quality, that it should be rejected, my Lord. I don't know if I answered the court sufficiently, my Lord.
Thank you.
My Lord, to add to the fact that there were lots of contradictions in the state's witness, Ms. Lombard, she was a single witness, the cautionary rule should be applied. There's another factor that comes into play, my Lord. Initially, we were faced with one version, that of Ms. Lombard. But after the exhibits of accused 1 and 2 were handed in, there's new evidence before this court, or a different version, if I can put it that way, my Lord. Their explanation as to what transpired differs from that of Ms. Lombard. And being faced with two versions, if accused number 3 were to be called to the witness box, which version is she required to answer to, my Lord? Because as it stands, we have new evidence regarding what is contained in the exhibit of Mr. Paulus and Mr. Van Rijn, and then we have Ms. Lombard's evidence.
Well, isn't that a choice that the defense makes? On a lighter note, I used to teach this subject in the old Law Society LEAD program. And I used to tell the young attorneys, don't get up and bring an application for a discharge if you can just close your case. Because when you get up for a discharge application, you must be so confident that if it's refused, I can close my case. Otherwise, you waste the court's time. Yeah, you weren't one of my students. You weren't one of my students. No, but I hear you, and it's something one has to consider carefully, because yes, there's no duty on the accused to strengthen the state's case, and there's no duty on the accused to incriminate herself, and the court must look at it objectively and try and prevent all the noise around a particular accused in the matter. So in this case, the perception might be that Ms. Smith is the mastermind, as indicated by some of the witnesses. But the state must still prove their case. So I will hear Ms. Lombard, and I am going to engage you.
There's no evidence, and that accused number 3 is entitled to a discharge. Those are my submissions, my Lord, unless there's any other aspect to comment. Thank you, my Lord.
Ms. Lombard, you don't have to address me on the application of Mr. Van Rijn. I don't want to hear you. But I want to hear you on the application for Ms. Smith. I'm sure you also went to look at the authorities. It's fairly trite by now what the test is. You've heard Mr. Sivanarayan and he honed in on that issue. You've also heard me on the holistic evaluation.
Yes.
What is your view?
Indeed, my lord, but may I just correct something? Lombard is not my surname. Lombard is not my surname.
Ms.
Thank you. No, on a lighter note, my lord, completely.
But I believe there's a Home Affairs office in town. Yes.
My lord, yes, indeed. I'm not going to address you on the law. You understand and know the law better than anyone of us
I don't
in
know
this
the law.
room.
I have to rely on going to check it up every time. I spent time last night to reflect on the evidence because I knew this application was coming. I was thinking it through in my mind.
Yes.
And I did go and look at the authorities. Simply because I've learned a hard lesson with the Lubatra case.
I understand.
I thought I knew it all.
Nobody ever
I was
does.
horribly mistaken.
Nobody ever does, my lord. Nobody ever does.
And things change over time because one also realized then of when all of these old authorities, like Shopping, like Mpeta, and so forth, and there were a number, a whole range of it, of cases, but they were all pre-constitutional.
Yes.
And if one evaluates the application of Section 174 in a constitutional era, it's different. Because it impacts on the fair trial rights of the accused.
It doesn't matter which application it is. Section 35 will always be applicable and must always be at the forefront of any presiding officer's mind when evaluating the evidence. But, my lord, making it applicable to this specific case. And there I would like to differ from my colleague. You cannot only look at the evidence of Laurentia Lombard in isolation. My respectful submission is, yes, I concede there is criticism against what she testified, and the court will carefully evaluate that. But, my lord, it's the state's submission that there is that golden thread of truth running through her testimony, even if there are reliable aspects in her testimony. The golden thread is still there. My lord, and I submit with respect that there's other evidence that corroborates her version. As my lord correctly now pointed out to that first part in accused number 1's statement, so also there is in accused number 2. So also there's strong corroboration found in Stephen Kutsia's testimony. My lord, setting up this whole idea of the transaction. And then we need to go back and look at what offense we are looking at. We are looking at trafficking in persons, which is it's on a complete different level of offense. when one looks at that offence, and specifically also the elements of the offence applicable there. My Lord, we must remember that when it comes to trafficking in persons, it is not a single act or a single happening that constitutes the offence. In fact, it is said, and that is also if one looks at the law, it is a process. Trafficking in persons happens through a process. And the purpose, and well, in this instance, we're dealing with a child victim. So we only have two elements. We don't have the third element. So we need the act and then the purpose. The means element does not need to be proved because we're dealing with a child. Section 11 of the TIP Act makes that clear. The so-called, or we refer to it as the defence section, Section 11. So we're only dealing with two elements, my Lord. The first one is the act, what was done, and then the purpose of exploitation in any form or manner. My Lord, the means is not necessary to be proved here, although I submit that the evidence indicates that there is means, more specifically in the abuse of the position of vulnerability of the victim, her being a child and her background and the social circumstances, as the state had led that evidence. My Lord, I submit with respect that this court needs to look at all of the evidence holistically. This purpose of this application is not to say whether the accused is guilty or not. That's not where we are. The test is whether there is evidence that a reasonable court, acting with caution, could convict. And my submission is there is. There's sufficient evidence to, in fact, say that a court can come to that conclusion. My Lord, so with respect, I submit that the applications for discharge, both of them should be dismissed at this stage, and that the accused, and then specifically Ms. Smith, should be called and put on her defence. Thank you, my Lord.
Yes, thank you. I am going to give my order, my ruling on this application. And I'm not going to give reasons for the finding. For two primary reasons. One is that this finding is in itself not appealable at this stage. Secondly, for the court to summarize all the evidence and draw conclusions therefrom, it might be premature, as that is not the way the court evaluates evidence. It might also be that it will impact by giving reasons the fair trial rights of both the state and the defense. But I am going to explain what the application is about. Because of the public interest in the matter and the public's right to know what's happening with the court process. So it is so that when a person is charged with a criminal offense, the state bears the onus to prove the guilt of that person beyond a reasonable doubt. Furthermore, as I've explained when I explained the Section 204, process to Ms. Lombard. Nobody is obliged to incriminate yourself. And there is no duty on the accused person to supplement the state's case to prove your own guilt. There are certain considerations, which are considerations of fact and law, that the court takes into account at this stage of the case. And the test is fairly simple. That because the state charges the accused and bears the onus, if at this stage of the trial, meaning the end of the state's case, the court is of the opinion, and by saying that, it is clearly something subjective based on the objective facts before the court. So it's the view that the court forms of the evidence that there is no evidence that the accused committed the offense referred to in the charge or the offenses upon which that individual may be convicted of that charge. And all of this must be evaluated looking through the prism of a reasonable court. Whether a reasonable court, on the available evidence, may come to the conclusion that the person is guilty. If the answer is no, then, unlike as at the end of the case, where there's reasonable doubt, a person is acquitted of the charge, the law dictates that if the court comes to that conclusion here, the person is to be found not guilty. So there's a difference in that, the order as well. Now, I have an application from Mr. Van Rijn and Ms. Smith for them to be found not guilty at this stage of the trial. I've heard the arguments for the defense as well as the state. I had the opportunity to consider the evidence led up to yesterday afternoon, because there was nothing really this morning. This morning was a waste of time. I also anticipated the applications to be brought. I anticipated what the arguments were going to be. That's why Mr. Saldanha could say that I've referred to all the cases that he would have referred to. I've also anticipated what the state's argument was going to be. Simply because everything was before me already. And on the basis of the facts that's before me currently, and the application of the legal issues as I understand it, I'm not of the opinion that there is no evidence upon which a reasonable court might convene in relation to both of Mr. Van Rijn and Ms. Smith. for that reason, the application for a discharge for Mr. Van Ryn and Ms. Smith is refused. Thank you, Mr. Adamson. And I just forgot to mention, full reasons for this order will be incorporated in the final judgment, as it might be an issue that can be the subject of an appeal, or in the appeal, in the event that an appeal take place, where it can be one of the grounds of appeal that I should have discharged. So the reasons will be incorporated.
May it please the court, my lord. My lord, the defence on behalf of accused one, Mr. Pollis, elects that Mr. Pollis will make use of his right to remain silent in terms of the Constitution, section 35(3)(h), which guarantees every accused person the right to a fair trial, which includes the right to be presumed innocent, the right to remain silent, and the right not to testify during proceedings. On that score, I would request, with your court's leave, that your lordship confirm with Mr. Pollis that that is indeed his instructions in me, and that he is indeed elected not to give evidence.
Are you going to call any witnesses?
The defence will then therefore not call any witnesses. May it please go.
Thank you. Now, Mr. Pollis, you must listen very carefully. Mr. Adams is doing the right thing by requesting me to just confirm with you. I am informed that you elected not to testify and not to call any witnesses. Is that correct? You nod. Do you understand that you have the right not to testify and not to call witnesses and to close your case? But it might also have consequences. Do you understand that? Good. Although there's no microphone, I could hear the accused say, "Ek verstaan." The interpreter sitting right behind the accused person, Mr. Pollis. So I will now note that the case for yourself is closed and that no evidence will be laid on your behalf. You confirm that? Good. I can hear and I can see the person saying he's in agreement. Thank you, Mr. Adamson. Thank you, Ms. Mkabai.
Thank you, my lord.
Let's just adjust. Thank you.
Mkabai, on behalf of Mr. Van Ryn, Mr. Van Ryn chooses to exercise his constitutional rights, not to testify, not to call witnesses, to remain silent, my lord.
Thank you.
Humble request the court to confirm same with Mr. Van Ryn.
Thank you. Thank you, Ms. Mkabai. Mr. Van Ryn.
Thank you, my lord.
Did you follow the explanation I gave to Mr. Pollis? I can hear Mr. Van Ryn says, yes, my lord. You also understand what I've explained to him? Confirms? And you confirm that that's the election you make? Thank you. So confirmed. The case for Mr. Van Rijn is then also closed. Mr. Siebenrein. Have you taken instructions of the refusal?
My Lord, I am actually seeking the court's indulgence and request a very short adjournment in order to take instructions.
How long do you need? Half an hour, because I take it you need to consult and take instructions.
At least 20 minutes, my Lord, would be sufficient.
Can I give you half an hour till 11:30?
Thank you, my Lord.
Court ledger. because you need to go and prepare, and I'm sure from the state side, because you're going to have the bulk of the argument, that you would want to go and connect the dots, extract from the evidence that you want to extract. It will be easier from the defense perspective because there's no evidence from the defense, so they will have to answer to your argument. I'm thinking the following. We have the argument on Tuesday morning. It'll give you tomorrow, and you've got the whole Friday, Saturday, Sunday, Monday. Would it be too much to ask of you, Ms. Swanepoel, if you're going to do brief heads of argument, if you can provide that to the defense by Monday morning, so that I anticipate you're going to be on your feet for at least half the day on Tuesday, because you're going to take me through the evidence, you're going to point me at certain things. And similarly, if you then provide your heads of argument to the defense, you can also provide it to me electronically. So we have the argument for the state Monday, part of the day. We'll start with the defense. If on Tuesday, because Monday is a public holiday, if we can then try and conclude, if we conclude the arguments on Wednesday, both state and defense, I will give judgment Friday next week. In other words, I will start working through it now already on my own summaries. I don't do judgments, he said, she said. That's not my style. I tell a story. I will have your heads by Monday. I will have the oral arguments Tuesday, Wednesday. I will then take the first that we will not be sitting, and I will preparing my judgment, which I will then give on Friday the 2nd. That's my time planning. Will that suit you, Mr. Armson?
Possible to provide the defense with the state's heads a little bit just before Monday. So we have Monday at least to it's not that we'll only start working on Monday on it, but at least work through it.
No, I understand that. I want to say the latest Monday morning, so that you have it Monday morning. But if it's at all possible, Ms. Swanepoel, at your earliest convenience.
My Lord, I will.
Let me just hear Mr. Kabai, Mr. Sivnarine, and then we can do the necessary housekeeping. Ms. Kabai.
Thank you, my lord. That was going to be my suggestion also, that we get the heads before Tuesday.
Good. Mr. Sivnarine.
For Monday.
Before Monday.
Yes, before Monday.
Sunday afternoon, Ms. Swanepoel. You have today, it's still early in the day. You've got tomorrow is Thursday, you've got Friday, you've got Saturday, you give it to them on Sunday. Please. Okay. Just for housekeeping's sake, there's a lot of evidence. Now that there's no evidence from the defense, which is evidence that is unchallenged before the court. The only evidence from extract from which is now common cause evidence, from that. So, and you will point me to issues that you want me to draw inferences from. I've mentioned some of them in the argument on discharge. And I don't know what the argument would be. I can anticipate. Insofar as it relates to Mr. Apollos and Mr. Van Rijn, those are factual issues, primarily factual issues, because the statements are there, it's evidence before the court. And then the argument contrasting that with what the state's case was, and whether in any event that satisfies the elements of the offences of whichever you want them to be convicted of. And of course I'm not bound by what the parties tell me. I'll have to consider that myself. Insofar as it relates to Mr. Saldanha and Ms. Smith, there's going to be a big legal argument. And that's the value, firstly, the admissibility of evidence insofar as it relates to her, and more particularly, stuff that comes out of the statements. Some of the same arguments that were raised in the discharge application. And there are some legal issues that Mr. Saldanha might want to focus on. So hence I'm saying, if you're going to do heads of argument, oral argument shouldn't necessarily take that long. First prize for me, if by Tuesday afternoon, earlier in the day, I can get it shot off. I can start work on that. I don't know what your style is. You've never appeared before me. I prefer to do a mind map. If you are able to do that, so I don't know your style, I don't know your ability to work with technology. But if you're going to do something like that, I will not be averse to a mind map of literally connecting the dots and little boxes. You told me during the course of the trial that you think in pictures. It gives us a very good idea, and it will also assist your colleagues where they will be able to say, this is the line where we're going to break it. So you can't complete the circle, and they'll hone in on that. It just makes it so much easier for us. Now, it's a lot of work. Similarly, I've asked the state to present me, when she gives you the heads of argument, to send a copy to Ms. Nadu Chetty. Can I ask all the parties, whatever authorities you want to refer me to, because you will know before Tuesday morning which authorities you're going to refer me to. Can you just send the list of the authorities to my registrar? I'm not going to ask you to print any authorities, because it's very difficult and I don't want to sit with bundles. She will then upload the authorities, and we'll have a discussion between the two of us whether we can create a bundle, an electronic bundle. If you want to send the electronic copies of the Safely link, or some of those matters will not be on the electronic library, except that one can access the SA law reports, the criminal law reports, the constitutional law reports, and some of the foreign law through access that we have, so that we have it available. We will then, once we have the electronic record of the authorities, I will have it open, available here. So I'm going to set up the court on Monday slightly differently, so that we are able to open the multiple authorities. I want to forewarn you. And I'm giving you this long speech now because simply we have time, but I don't want any misunderstandings. I don't want a repeat of last week. If counsel refer me to any authority, I expect you to have read the case. And not only the head note or a summary that you find in some obscure place. Because in the event that I'm going to be under tremendous pressure, we're looking at 34 days of trial. I'm going to literally have 1 day to prepare judgment. And I'm willing to do it, but I need your assistance. I don't want to make mistakes if I can avoid it. I will do my part to go and look at the cases, but I want to be in a position that I can trust counsel to assist me. That's the whole purpose of argument. So if you mention a case, I want to know that it's on point. It's not just some peripheral issue, and it's not applicable on the facts. Please, I'm asking you to assist me in that regard. There's not much to do for the three of you in this exercise. Mr. Paulus, Mr. Van Rijn is fine in Malmesbury. We now have a break of 6 days. From today, it's Thursday, Friday, Saturday, Sunday, Monday, it's 5 days. Coming back on day 6. I'm thinking of, where do I remand Ms. Smith to? For the length of the trial, it was convenient that she stays in Langebaan because it's close by. I don't know what the situation will be between now and Tuesday. It's similar to last weekend. Let me just check with Mr. Sivnarine on that. Mr. Sivnarine, do you have any input? Do you have any views? Because the police cells are not geared for long-term, unless if she's okay, then I can arrange that she stay there.
My Lord, I'm not sure what options are available to predict. Can I take the instructions?
The only other options would be, it's Bolsmoor, that has a female section. The other option is Worcester, as far as I know. Those are the only two correctional centers that I'm aware of where there's a facility for female inmates. But if Langebaan police cells can cope, I'm willing to do that too. I've heard from the court orderlies that about
Thank you, my lord. Thank you, my lord. My lord, accused number 3 requests that for the duration of the weekend she be taken to Portsmouth.
Okay, I'm going to find out what the logistics would be, because that's another issue.
Yes, my lord. Thank you, my lord.
Logistics.
My lord, then transport is again an issue to bring her back from Paulsmoor here. So then possibly we would need a J7 for her for Monday, so that on Monday she can be
No, that's
collected and brought to.
that's fine. I can do the J7. I can do 2 J7s.
Yes.
I do one for Paulsmoor from today through to Monday, and I do another J7 from Monday to Tuesday at Langebaan.
My lord, perhaps from the court orderlies, because I suspect that there might be things of a.
There's a lot of logistics around
Yes.
that, because nobody was planning on that. Means if she goes to Paulsmoor today, special arrangements have to be made for the transport to Cape Town and it will be SAP's uniform police, I take it, that will have to take her. Then on Monday, they will have to dispatch a vehicle from here again, going down, bringing her back, which might also be a logistical issue. So I'm going to take an adjournment. I want us to clarify those issues. I don't see the warrant officer here. Okay. So I'm going to have a word with the warrant officer, who is responsible for all of that, just to see whether me ordering her to go to Paulsmoor will not create unnecessary pressure and or inconvenience, because you must remember, it's driving there today, getting to Paulsmoor from here. It's now 12 o'clock, almost 12, 10 to 12. Means they're going to hit the peak hour traffic. Once they take the M5, M3, then they have to come back here tonight. The same police officials have to drive back, sitting in peak hour again, trying to get back here. Then on Monday is not that much of a muchness, because it's a public holiday, there shouldn't be a lot of traffic, but it's still take it a 400-kilometer return trip. If today is going to be an issue, they might say, okay, let's take it tomorrow morning, because we can do it during the course of the day, but I want to sort out all those logistics. I don't think we need to resume the court session. If counsel is okay with it, I can make that call once I've got all the information. Happy? So, Ms. Smith, you will either go to Paulsmoor today, tomorrow, or you will go back to Langebaan. I just want to get the logistics and see how it can work out. And the reason I'm looking at a correctional center rather than the police cells, because I'm aware the police cells are not geared for that. You, however, have been there for a while. I take it you've built up a relationship with them for clothes, medication, etc. You happy either way in any event? Not happy, but you can never be happy to be in a the cell or incarcerated, but I'm going to sort it out and then we'll do it that way. So I will endorse the warrants for Mr. Smith and Mr. Apollos now because it's a different vehicle that takes them to Malmesbury, and I will hold back until the warrant officer comes back, and then I'll have that discussion with him. Tuesday morning, can we start at 8:30? Simply because we need to make up the time. Yes, 8:30. Office must arrange that you come through and so on Monday. I'm not going to start late because of all the work we need to do in order to fit in with our time frames. Subject to what my judgment is on that Friday the 2nd, it can either be the end of the whole case in the event that I acquit everybody, then it's the end of the case. In the event that there's another step for any or all of the accused, we will cross that bridge when we get to it. In the event that we go there, we won't immediately come back that first week. We'll have to make the arrangements with the municipality. And then I'll most probably come down for 2 days or 3 days in the middle of the week and attend to that part of the case. And those dates will be arranged. But we'll cross that bridge when we get to it. In the meantime, you must also ensure that if you need any special arrangements for setting up your equipment on Monday, on Tuesday, just liaise with our assistant over there, subject to how you want to do it. I expect there's going to be a much bigger showing next week of members of the community. Right, any questions, anything, Ms. Swanepoel? I almost called you Lombard again. Mr. Adamson? Ms. Mkabai? Thank you. For council having to travel back to Cape Town and all the other officials, have a safe journey. We will most probably only leave tomorrow morning because we need to pack up. We didn't anticipate this. And you can stop Ms. Eramuna from coming back. Thank you, the court will adjourn.